Welcome to Legal Bites. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we make sense of the law one bite at a time. Whether it's live trials or splashy legal headlines, we are here for the facts in the law and no nonsense. Well, unless it comes from our furry four-legged friends, of course. Here is where you bring your unique perspective to agree or disagree with other people, but please, always in a way that's civil and productive. After all, we're here to get to the bottom of the truth with a capital T, and the best way to do that, of course, is with healthy dialogue. So, if that's what you're looking for, jump on in. We would love to have you. Let's get started. All right, you guys. Good morning, good afternoon, good evening. I hope you guys are having a good Tuesday. Happy Tuesday. Obviously, the subject matter is not particularly happy. This is a very difficult case that we're talking about, which is Ohio versus Chad Doerman. If you are familiar with the case, we're gonna get into like the pertinent factual background that is, in this motion. But yeah, this is one of those that I'm not gonna be able to live stream from gavel to gavel because this is one of those cases that I just can't live in. But this is a very important issue that came up in this case, and it's because of how strongly disliked this defendant particularly is. I mean, a lot of times these defendants are not particularly liked that, in these cases that kind of make it to public airwaves. But sometimes there are, of course, defendants who have have a backing of people, right? Like Karen Reed is one of those. She's got her supporters. But this is one of those that I think he's pretty universally disliked. And this is because of the fact that he is charged with the murder of his 3 sons. Apparently, he did it in front of their mother and their sister. He also is, he apparently confessed to it multiple times. And that's kind of the subject of this live stream is what happened during those confessions. What is Miranda rights? What's required for Miranda rights? What are the consequences of not informing a criminal defendant of their rights? And so, this is like I said, this is a very difficult case, but this is an important subject to cover because even for a criminal defendant like this, who is very universally disliked, we have to make sure that our judicial system is fair and impartial. So yeah, I'm not going to get into the crazy nitty-gritty details of the underlying facts in this case because, like I said, it's a really hard and heavy case. But we are going to get into the issues here about Miranda rights. It's something that comes up quite often. I mean, we talk about it basically at any time. Anytime there's a confession that or an interrogation that's played at trial, folks have questions about it, and understandably so. So we're going to get into, like I said, all of those requirements and everything else. If you folks have questions in the chat, let me know. I'll save them and answer them, whenever I can, either while talking or maybe at the end. But I will, I'll answer them whenever I can. So just let me know if you've got questions. Chrissy, when is the trial set to start? I actually don't know the answer to that question. I don't know if there is a trial date for this one just yet. So yeah, I don't know. Maybe someone in the chat has the answer to that, and I apologize for not having that answer. Okay. Let's get into it, shall we? And also, let's get our emotional support dog here for this one. Indy. Okay. Good. Hopefully she stays there. Okay. All right. Let's get started, shall we? I hope you guys can read the font here. I'll make this a little bit bigger so that you guys can hopefully see this a little bit better. But you can see this is State of Ohio versus Chad Doerman, decision and entry on defendant's motion number 42. So we're reading the court's ultimate order on this issue. And I'll just start off by saying I completely agree with the court here. It's from what I know of this case, this guy is very much not a sympathetic defendant. And But I agree with the court's decision here. Because like I said, we have to maintain impartiality and fairness for all criminal defendants, regardless of how detestable we find them to be. Okay. All right. So let's get to the pertinent factual background. Actually, before we do that, let me give a little bit more background on this. So the issue here is whether or not the confessions that he made to various people while in custody, whether those can be thrown out. There are 3 of them in question. The first one is they call it the custodial sorry, hang on one second here. Um they call it the custodial interrogation. And then the court refers to 2 other ones kind of together because they're very similar to each other. There's the butcher interview, which is not a reference to any sort of acts that may have been made. This is related to the name of the person that he was talking to, Miss Butcher. She was the social worker who was interviewing him for his mental health. And then there is the Griffin exam. So it's referring to Miss Griffin, who was giving him medical care after he mentioned to Miss Butcher that he was having like heart palpitations or something along those lines. So so there's these 3 different conversations that he had with different people. And so the court goes through each one to determine, whether or not these were proper. And before that, the court also goes into whether or not the defendant here made a voluntary, whether his statements were voluntary to the police or whether they were coerced. So there's a whole analysis that goes into that. We'll get into that too. Okay, let's first do the background here as the court lays it out. So pertinent factual background. Oh, and by the way, I'm so sorry, guys. This is like my brain's kind of going in a few different directions. Linked in the description below is a link to the actual decision itself. The full order is 31 pages. We're not going to go through all of it in detail because it's, like I said, it's 31 pages. But if you want to read the whole thing, I highly encourage you to, because it goes into some of the main Supreme Court cases on Miranda as it has developed over the years since the Miranda case, to kind of talk about some of the nuances of how they've sort of come out in terms of what the requirements are, how rigid are those requirements. It gets into some more detail. We're going to kind of gloss over some of that, but if you really want to know the ins and outs of it, go ahead and read the order itself linked in the description below. Okay, pertinent factual background. The defendant is alleged to have killed his 3 young sons, ages 7, 4, and 3, on June 15th, 2023. Whew. We're not going to get into the details there of that. It is also alleged he seriously wounded another child and his wife. The defendant was apprehended at the scene and immediately taken into custody. He was secured in the backseat of a deputy sheriff's SUV cruiser that was parked along Laurel Lindale Road, some distance from the actual crime scene. He remained in the cruiser for about 50 minutes until he was transported from the scene to the sheriff's office in Batavia, Ohio. A Claremont County grand jury returned a 21-count indictment against the defendant on June 22nd, 2023. He stands indicted on 9 counts of aggravated murder, each coupled with 3 capital aggravating circumstances, 8 counts of kidnapping, and 4 counts of felonious assault. So very, very, very heavy case here. Okay. So then they get into, what happened at the hearing, what kind of evidence they heard. We're not going to get into that. And then the motion to suppress itself. Okay. Now we're going to get into a number of issues that are raised as to the custodial interrogation, because he makes some allegations as to the police communications when they put him in the police car, and then when he's actually in the station, and then after that when he's talking to these other medical professionals, right, or social worker, what have you. Also, I apologize if Batavia is not how you pronounce Batavia. In my last upload that I just put up yesterday, I realized I was mispronouncing Spokane, Washington. So now I'm a little bit. People let me know in the comments. They will always let you know. So it's all good, but it of course has me wondering. The parts of the United States that I haven't lived or haven't spent too much time in. I'm pretty sure it's Batavia, but if it's not, I apologize in advance before anybody lets me know. Let me know if it's pronounced differently. Okay. Pity saying you are pronouncing it correctly. Thank you. I appreciate that. Okay. All right, back to the case. The custodial interrogation. The defendant raises a number of claims regarding the custodial interrogation. So that's referring to when the actual police are interrogating him. Conducted primarily by Detective Ross at the sheriff's office on June 15th, 2023. The court summarizes these claims as follows. So there's 5 of them here. First, Detective Ross failed to properly advise the defendant of his pre-custodial interrogation rights as enunciated by Miranda v. Arizona, so his Miranda rights. 2, a valid waiver of the defendant's Miranda rights was not obtained because Mr. Doerman was never presented with a written copy of his rights. 3, a valid waiver of the defendant's Miranda rights was not obtained as Mr. Doerman was never asked to sign a written waiver. 4, the defendant unequivocally invoked his right to counsel, yet the custodial interrogation continued thereafter unabated, and the detectives employed outrageous police conduct during the custodial interrogation to such an extent that the will of the defendant was overcome, thereby rendering any statements made during the custodial interrogation involuntary. Now, I don't fault the defense attorney or attorneys for putting forth all of these arguments, even though some of them are definitely losing arguments. You want to put whatever you think has a reasonable chance of possible success in front of the judge and let them strike it down, right? With the exception of you don't want to go so far as to really put forward a crazy, ridiculous argument, because then you risk looking like an absolute fool in front of the court and everybody else. But these are all within the realm of arguable claims here. And the court first, just right out of the gate, gets rid of a few of these. So the first ones that have to do with the fact that the Miranda rights were not there was no written waiver. He didn't sign some kind of a written waiver, and then the fact that he was never presented with a written copy of his rights. These were taken out right out of the gate because the judge said there's no such requirement. You'll often see in some of these cases, like in the Hannah Gutierrez Reed case, for example, she had a written copy of her Miranda rights that was given to her. She signed it on the, so that it's, she's got an affirmative signature. That is best practices. And in some jurisdictions, it might be required, but at the very least in Ohio, it's not. And federally from the United States Supreme Court, it's not a requirement. So, states can choose to require a higher level of protection for criminal defendants if they so choose. But the level that is required both federally and in Ohio does not require anything to be in writing. So that's an interesting twist here that some people, may have thought it was required. So that's the first thing that is basically just dismissed outright. Then after that, we've got the issues of, did the detectives properly advise the defendant of his pre-custodial interrogation rights, so Miranda rights? And then also, did he make a valid not a valid waiver, but did he unequivocally invoke his right to counsel? And did the officers respect his invocation of that right? So those are the 2 main issues that the court really focuses on here. But before that, the court does get into this allegation about outrageous police conduct during the custodial interrogation. Basically, what the argument is by the defense is that the police went far beyond what they should have done, and as a result of that, they turned what could have been a voluntary a voluntary statement by the defendant or a voluntary waiver of his rights by the defendant and turned that into a coerced one. If it has been coerced by the police, then it's not a valid waiver of his rights, his Fifth Amendment rights. So the court gets into that, and let me just find here. Okay. So this is where they get into that first issue about whether the waiver was voluntary or involuntary. So, and this is the case law that they cite to here. If a defendant challenges a confession as involuntary, the state must prove a knowing, intelligent, and voluntary waiver by preponderance of the evidence. So, note that this is the state has to prove it. If there's been an allegation by the defendant that the confession was involuntary, the waiver of his rights was involuntary, that it was coerced, it's up to the state to disprove that by preponderance of the evidence. So this is why there's a pretty heavy burden on the police to, for example, have all of these interrogations on camera, have recordings of all of these things to make sure that their I's are dotted and their T's are crossed, because this is something that otherwise they could really get away with pretty easily if they were like, okay, it happened, it just wasn't on camera. So this is why there's there's a bit more of a burden on the police in these kinds of circumstances, because courts have said that the burden is on them to prove that. Voluntariness of a confession is determined by the totality of the circumstances, including the age, mentality, and prior criminal experience of the accused, the length, intensity, and frequency of interrogation, the existence of physical deprivation or mistreatment, and the existence of threat or inducement. So, I mean, it's, prior criminal experience of the accused it might make someone chuckle a little bit, that it's like, if somebody's a regular repeat offender criminal, if they're a professional criminal, so to speak, then they're used to this kind of song and dance. They know what's going on. They have an understanding. But if this is somebody's first time being arrested, for example, there might be a heavier burden on the police to inform this person about their rights. But then there's also, their age can play a role. If they are somebody who has lived a bit, been around the block, might have more confidence around the police versus somebody who's 17 or 18 years old. There's a difference. So the context of this really matters. Is the person starving? Is the person, on some kind of medication that they need, that they haven't had in some time? And is that being withheld from them? These are things that are incredibly important for this kind of an analysis. A waiver will not be deemed to be involuntary unless there is evidence of police coercion, such as physical abuse, threats, or deprivation of food, medical treatment, or sleep. So are they waterboarding this guy? Are they, keeping him from sleeping? Are they, employing various torture devices against him, whether they are physical or mental or emotional? Like there are ways of coercing this. Or, I mean, are they just putting basically a reasonable amount of pressure on him, to the extent that it might be uncomfortable, but it's still legal, and it's not putting enough discomfort on him to make that confession voluntary, or sorry, to render a voluntary confession coerced. All right. So, and basically the court concludes here that there's no evidence of any kind of physical abuse, threats, deprivation of food, medical treatment, or sleep to constitute any sort of police coercion. So this first one, and so we'll go through some of these details here. Where, let me see here. I always need to print it out, because that way it's like so much easier for me to actually take notes and highlight and all this stuff. Okay. So one of the arguments here was that there was something about his mental condition during the custodial interrogation that basically rendered his confession coerced as opposed to voluntary. However, The defendant didn't testify at the hearing, nor did he present any other evidence to even suggest what his mental condition was at the time. So the court was like, we're not required to go digging for something that's helpful to you if you don't if you don't present it to us. So nothing about his mental state, is going to render this suddenly coerced. So then they go down. Oh, so then there's this bit about some statements that one of the detectives made about him, something along the lines of he was walking past the cruiser. I guess Detective Schubert. He was walking past the cruiser when the defendant was sitting in it, and he made some sort of statements that were somewhat aggressive, I suppose. Let's see here. Let's see here. Is that the mofo? Yeah. Shut the door so I don't effing do something to him. Like that's like one of the statements there. Because this was at the scene or nearby the scene. Detective Schubert may have seen what happened at the scene. And maybe it may have had some feelings about what had happened there. So there was that statement that was made, but there's not even, as the court points out, there's not even any sort of claim that the defendant even heard that statement. So there's no allegation that the defendant heard them, and no evidence was adduced at the hearing that he did. There was also loud loud air conditioning that was on, and there was, the Detective Schubert was walking at like a normal pace. There wasn't anything about him like shouting this to make sure the defendant could hear. The evidence that came out at the hearing was that he made this statement with a normal sort of voice. So the idea here was that the defense was saying, so how would that coerce a confession? What they were basically alleging, what the defense was alleging here, is that, this kind of a statement made him feel threatened or something. He had no power, no agency in this situation because he was under the control of the police. This is one of the detectives, one of the officers who was who was, you know, one of the guys that was arresting him, who was making this kind of a statement, basically saying that like he felt threatened by this. But there's nothing here in the evidence that came out at the hearing to suggest the idea that he actually felt threatened. Like there's no statements he made, there's nothing in his body language, there's really nothing there. So the court says, the court finds it most unlikely that the defendant could have even heard these words. And during the final 40 minutes of the custodial interrogation, so back at the station after this point, Detective Schubert enters the interview room for the first time. So the defendant had already been in the interrogation room for a while before Detective Schubert walked in. So he had already been talking to the police for a bit. So you can't say that there's a causality issue there. You can't say that was something that induced him to start talking if he's not even present after making that kind of a statement before he starts taking or making any kind of statements. Okay. Just want to make sure that I have that covered, and then we'll move on. Oh, actually, and then there's even more. I mean, the court really goes into a lot of detail here. There's another issue about, one of the officers called him a monster a few times. It happens like 4 times in all of this. The word monster is first uttered by Detective Ross in Exhibit 4B at approximately 25 minutes and 31 seconds, and again at 25 minutes 51 seconds. And then there's like 2 more times that he calls him a monster or refers to him as a monster. However, the court says the use of this word was very limited, only spoken 4 times, and they were not uttered in any threatening or overbearing tone. Consequently, the court finds that uttering this word 4 times was not so overbearing or coercive that the defendant's will was overcome. Thus, the use of this word is not evidence supportive of the factors of police coercion as set forth in Garrett Supra. So this is one of the cases that it was pulling from. And so basically, okay, so they used a word that he doesn't like and described him in that way. That's not enough. That's not enough to to say that this was a coerced confession. Moving on down the line, then there's also this argument that there's to further drill home the point that this was not a coerced interview. There was one of the things that they mentioned was, in order for an interrogation or for a confession to be coerced by the police, they're looking for things like, did they have medication that was withheld? Did they have food or water that was withheld from them? Did they prevent them from sleeping? Sort of like we're almost thinking like torture territory here. However, here it's entirely different what happened. As noted earlier, the defendant's custodial interrogation lasted a little over 2 hours. During that time, he was given a bottle of water, a can of Coca-Cola, dipping tobacco, offered food, which he declined, and asked if he needed any medications, which he declined. So there's nothing. I mean, if he's a regular user of tobacco, sometimes that can be something that if he's feeling like he needs to smoke because he's relying on that, dependent on that, addicted to that, who knows? That's something that could potentially be used as like, well, they're withholding that from him so that he can get his fix, as soon as he talks to them. That's not the case here. They gave him dipping tobacco. They offered him food. They offered him water. They offered him a can of Coca-Cola, and any sort of medications which he possibly needed. And 2 hours is not it's not that long. Now, I will say that the 2 hours is separated by I think like an hour in between or something like that. The court did mention that there's an A part and a B part, and in between there's a bit of a break, but that doesn't count towards the interrogation time because he's not being actively interrogated. He's also getting a bit of a break in between. So, then the court goes on and says, while his hands were initially cuffed behind his back, just prior to the start of the custodial interrogation, Detective Ross loosened them and moved his hands in front of his body, which enabled him to stretch his arms from time to time, drink water and Coke, and put dipping tobacco in his mouth, and his ability to move his arms was less restrictive than at the outset. Detective Ross's demeanor and inquisitional tone throughout the custodial interrogation was calm and not threatening. At no time during the 2+ hour interrogation did any detective make any type of threat to the defendant. And the defense, having the same access to the recorded custodial interrogation as the state and the court, identifies none. So in other words, the court is getting at like, look, you can't argue that this is some sort of, bad clipping job that was done by the prosecution here, that they're not like cutting out some portion of this interrogation, or that you think is unfair. You have the access to the full bit of all of this, and you haven't been able to produce anything to the contrary either. At no time during the interrogation did any detective make any type of promise of any nature to the defendant, and the defense identifies none. There was clearly not one single act of physical abuse of any nature inflicted upon the defendant during the interrogation. And after more than 90 minutes of being interrogated, even called a monster, the defendant acknowledged that Detective Ross had been nothing more than kind to him and that he respected him. And a number of times during the custodial interrogation, the defendant said he was not afraid or scared. So, it may, and you could take a step back from this and play devil's advocate and say, maybe this was just him trying to put up a front, in front of the police, right? But that's also where words have meaning. And in cases like this, you have to mean what you say and say what you mean, because courts will take it that way. So there's that. I think, okay. So basically the conclusion here is that the statements that were made were voluntary. There's nothing about the actual conduct of the interrogations that renders this involuntary. So defense loses on that one in motion to suppress. But then we get into the other issues, the issues as to whether or not he was properly warned of his Miranda rights and the risks of waiving those rights. And then also, did he properly, unequivocally invoke his right to an attorney. These are where the defense really makes some big headway. Let's move on down. Let's see here. Okay, so we're going to kind of gloss over this stuff here, but they get into, the Miranda decision itself. Justice Ginsburg referred to it as a path marking decision. This was a very important landmark case. She said, to summarize, we hold that when an individual is taken into custody or otherwise deprived of his freedom by the authorities in any significant way and is subjected to questioning, the privilege against self-incrimination is jeopardized. Procedural safeguards must be employed to protect the privilege, and unless other fully effective means are adopted to notify the person of his right of silence and to assure that the exercise of the right will be scrupulously honored, the following measures are required. He must be warned prior to any questioning that he has the right to remain silent. So here it's going to outline basically the four main elements of a proper Miranda warning here. Number one, he's got to be warned prior to any questioning that he has a right to remain silent, that anything he says can be used against him in a court of law, that he has the right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. So those are the four elements. So you have the right to remain silent. Anything you say will be used against you or may be used against you in a court of law. That you have the right to the presence of an attorney, and that if you cannot afford an attorney, one will be appointed for him prior to any questioning if he so desires. Now, in the original opinion in Miranda, the court says you have they have the right to the presence of an attorney. Now that's more of a generic statement, but where people seem to be getting into trouble, particularly in this case, we'll take a look at it more closely. But where people get into trouble is when they specify you have the right to the presence of an attorney before any interrogation, and they don't say also during. So if they had just said you have the right to the presence of an attorney and left it simply at that, that covers it. One of the things that they get into in the cases that follow, the court goes through the jurisprudence afterwards, right? That the cases that follow, 1981 and California v. Prysock, the court determined this, then they moved on, yada, yada, yada. Basically what they're getting at is the court really takes a long time to go through and say, the Supreme Court has said these are the four elements. These are what's required, right? These four warnings in order for this to be a proper interrogation, a proper waiver of these rights prior to this interrogation is you've got to have these four elements in the warning. However, the Supreme Court has also said that it's not like some sort of talismanic recitation. That's like one of the phrases that they'll use. Like it's not talismanic, meaning it's not like a very specific series of words that you have to say, and that if you miss one word or something like that, that it's, that everything's messed up. No, it has to be communicated in such a way so that a reasonable person hearing all of that understands the rights that they have and the rights that they are waiving. So it's like it doesn't need to be like contract language or like, analyzing a will, some of this case law went into. But basically it just has to be like if you don't say these exact four things, you have to say things in a way that essentially covers it and covers it in a way that a reasonable person would understand what you're saying and understand that their rights are being identified in what you're saying. So that's what they get into here. Now, so they go through, some of these other cases where this got tested in various ways. And we're going to skip on down because, if you guys want to read these in detail, like I said, I highly recommend it. It's very educational, but we're not going to go through each of these here. Let's see here. Okay. Now we're going to get into what actually happened here. And the thing that happened here is that he actually had a Miranda rights card that the Claremont County Sheriff kind of gives out to all of their police officers to make sure that they get it right. So the rights card, this is what the rights card says. Oral warnings to be given to a subject prior to interrogation. Before we ask you any questions, you must understand you have the right to remain silent. Anything you say can be used against you in court. First two elements. You have the right to talk to a lawyer for advice before we ask you any questions and to have a lawyer with you during questioning. That's the third one. If you cannot afford a lawyer, one will be appointed for you before any questioning if you wish. That's the fourth element. Do you understand these rights? Are you willing to answer some questions? So if you go through, if you read this verbatim, you go through bullet point by bullet point, and then you say, do you understand these rights? And they say yes. And then you say, are you willing to answer some questions? And they say yes. You have a proper Miranda waiver, regardless of whether it's in writing. If it's on camera, you've got it recorded, boom, you're in business. That's not what happened here, though. What happened here was he didn't exactly read it verbatim from the card. And I don't know why. Maybe he was in a rush. Maybe he was unfocused. I have no idea why. I don't know this detective from Adam, so I I don't know. I can't speculate. But this is apparently what he said. Between 39 minutes and 51 seconds and 39 minutes and 59 seconds, and reading from the rights card, Detective Ross advises Doerman of the following Miranda rights. 1, you have the right to remain silent. 2, anything you say can be used against you in court. 3, you have the right to talk to a lawyer before we ask you any questions. 4, if you cannot afford a lawyer, one will be appointed for you. So, spot the issue, right? Spot the problem. What's missing here? What's missing here is, what about having a lawyer during the interrogation? It's not covered here. And there's nothing here that properly covers it. One of the cases that the court went through before getting into this particular case, when it went through the jurisprudence of Supreme Court cases talking about Miranda rights and all these different situations, there was another one that was similar to this and said, like, you have the right to talk to a lawyer before we ask you any questions, and then if you can't afford a lawyer, one will be appointed for you. And then they said, and you also have the ability to invoke these rights at any point during the interrogation, which is not one of the four elements that's enumerated in the original Miranda opinion. However, the Supreme Court has said, if you say that, I mean, that's any person that hears that understands I can invoke this right at any point during the interview. I can invoke my right to a lawyer at any point in the interview. That's sufficient. That's enough. But here, he doesn't do that. He says you can have a lawyer before we ask you any questions. He doesn't say anything about the right to a lawyer during the interrogation. And that's what trips him up. So, Doerman says, yep. Detective Ross states, you understand. Oh, good. And what the court says is, as clearly exposed in State's Exhibit 4A, Detective Ross inexplicably completely omitted the third invariable Miranda warning that he has the right to the presence of an attorney during questioning. Also of critical importance is the detective's failure to adopt any other fully effective means to notify Doerman of his invariable right to fully advise him of his right to silence. So, like I said, they said that he doesn't have there's no statement here about the right to the presence of an attorney during the questioning. And then there's no alternative that he gives that's sort of like a catch-all that sort of covers everything. So that's the important thing here. He simply embarked upon his interrogation of Doerman at 40 minutes and 5 seconds. Accordingly, the court finds that the detective did touch all of the bases required by Miranda. And the detective here did not advise Doerman of the full contours of each Miranda right. So that is that on that point. So he gets tripped up on that. Now, moving on down as well, then there's the issue about his invocation of an attorney, and we've definitely talked about this before, right? This is another important point here, is that when somebody requests an attorney, you can't if you it really matters how you say what you say, right? If you're sitting in an interrogation room with a police officer and you say, "Do I need an attorney?" That's not enough. That's ambiguous, because you're asking them if you need one. They can just look at you and be like, "I don't know. Do you need one? I don't know." like they can't advise you as to your rights. They may or may not know if you need one. But if you say, "I need an attorney. I don't want to talk to you any further until I have an attorney present. I want to talk to an attorney before I answer anything else. That is the that is unambiguous, and it's a statement, it's not a question. The more firm you are, the better it is for you in the analysis as to whether or not you have invoked your right to an attorney. So here, the court goes into all of this here. And the thing is, it has to be in context too, right? You've got to look at the full context of the situation also, because there are sometimes some context cues that you can look at, some portions of the statement here that Doerman made and say that sounds ambiguous, but then other portions sort of help to firm up the unambiguity of his statement here. So, stating from the Ohio Supreme Court, to invoke the right to counsel, the suspect must make an unequivocal request. The person must articulate his desire to have counsel present sufficiently clearly that a reasonable police officer in the circumstances would understand the statement to be a request for an attorney. This is an objective inquiry. Courts are required to examine the appellant's words not in isolation but in context. So like I said, it's totally contextual. It's got to be it's got to be looked at in context. So okay. I'm repeating myself now. Okay. Then going into okay. Page 21. So what actually happened here? All right. So we'll go through kind of what the detective asks Doerman in the interrogation. So 42 minutes and 18 seconds into the recording. So the questioning started at 40 minutes and 5 seconds. So this was, right after the Miranda rights were almost given, almost properly given, but not quite. Doerman, so he starts this question at 40 minutes and 5 seconds. At 44, Doerman requests a lawyer. So it starts out, so context cues here with the writing is not the best here. It took me a second to realize they're now, when they say during this time period, they mean like at the beginning, at like 40 minutes, 5 seconds. Detective Ross asked a number of questions, most of which are not about the events of the day, but rather questions about a prior contact between the 2 years past and how he was feeling at the time. Doerman would respond to some of these questions, but would remain silent after some. At one point, when Doerman was not responding to his questions, Detective Ross asked him if he was thinking and if he was all right. Doerman did not respond. So the court kind of refers to Doerman at one point as basically being very difficult to interrogate. It's like pulling teeth, the court literally says in this opinion. And so then Detective Ross asked Doerman, why don't we do this? Why don't you tell me what's happening, what happened today? So this is at 42:18. Doerman responds over the next 20 seconds or so. Doerman responds to some additional questions posed to him, but he's basically like, the Detective Ross has to change gears and ask him when he last ate, slept, if he was thirsty or hungry. Doerman would answer some of these questions and not respond to others. So he's really not being very responsive at all, which means to say that like, it's not like, he's word vomiting everything that happened to him today. But rather he's really being very difficult to examine. And the thing that is helpful with this is that, there's really nothing that he gives before this point in the interview, at least helpful to the defense. Between 44 minutes and 40 seconds and 45 minutes and 6 seconds, Detective Ross poses about 5 questions about the day's events. Over the following several seconds, Doerman answers some questions, but not others. Finally, at about 45 minutes and 43 seconds, Detective Ross asked if Doerman was saying he just lost his way, and without hesitation and almost interrupting Detective Ross at 45 minutes, 44 seconds to 45 minutes, 55 seconds, Doerman states, I'll wait for a lawyer. I really don't know. Give me a couple days. I can talk to a lawyer and get nice, good answers. Detective Ross responded at 45 minutes, 57 seconds. I understand. Then at 46 minutes and 3 seconds, Detective Ross asked Doerman, "Do you have a lawyer?" So, um, so from his apprehension at the scene, his placement in the cruiser at the scene, and during his transport to the sheriff's office, Doerman remained totally silent for over 1 hour while in police custody. So there's really nothing that he gave before this point, that they can try to, argue, while he already volunteered that before this. Now, yeah. So like I said, the court can best describe this interview process as one trying to pull teeth. So then the court goes through these four clauses, right? This statement that he says, this invocation that he has. I'll wait for a lawyer. I really don't know. Give me a couple days. I can talk to a lawyer and get nice, good answers. So there's four clauses that the court breaks this down into to basically give the full context of what he said. Is it ambiguous or is it unambiguous? The first clause of Doerman's statement, "I'll just wait for a lawyer," is not a question, but a declaration that he wants a lawyer. The court believes that an ordinary person would understand this declaration unambiguously refers to having counsel present. So that's for the first clause. The second clause, "I really don't know," could be considered ambiguous. Does it mean he really didn't know if he would wait for a lawyer, or he didn't know if he had lost his way? The last statement from Detective Ross before the statement was made, taken in isolation, and if Doerman had stopped talking at this point, it is possible that an ordinary person might not understand the first two clauses unambiguously referred to having a lawyer present and lead to a finding that Doerman did not unequivocally invoke his right to counsel. So if he had said, "I don't know," immediately after, so let me get back to the statement as it's in one piece here. If he had just said, "I'll wait for a lawyer, I really don't know," that could be um, interpreted as ambiguous. But as the court says, he didn't stop there. Um, but Doerman did not stop. The final two clauses of his statement, "Give me a couple of days, I can talk to a lawyer and get nice, good answers," convinces the court that an ordinary person would understand these declarations unambiguously refer to having a lawyer present. And coupled with his statement, "I'll wait for a lawyer," leads this court to conclude that Doerman unequivocally invoked his right to counsel. This conclusion is bolstered by Detective Ross's responses to Doerman's declaration, "I understand, and do you have a lawyer?" So, I mean, yeah, because what the analysis says is, it does would a reasonable police officer understand that that is an unambiguous that is an unambiguous invocation for his right to an attorney? Um, and the thing is, if Detective Ross responded in this way, saying, "Okay, I understand. Do you have a lawyer?" That sounds like he understands that he's invoking the right. So not only is there like this objective standard, it helps that there's evidence of a subjective understanding that this officer actually did understand what he meant, and by responding, "Do you have a lawyer?" Therefore, construing the totality of the circumstances leading up to Doerman's declaration and the full context of all the words spoken by Doerman at the time he asked for a lawyer, the court finds he unequivocally invoked his right to counsel. Detective Ross was required to stop questioning him immediately, and no evidence resulting thereafter from the interrogation can be used against him. Now, here's a good question, Draco Amy Live. If they ask for a lawyer but then keep talking, does that negate the right? So, the question is, for that, to get to the answer for that, to get to the answer to your question, we have to ask what happened in between his invocation of his right to an attorney and him continuing talking. If there were no questions between then, if he said, I don't want to talk until I have an attorney, no one has asked him a question. No one has really said anything else in response. And then he just word vomits a bunch of stuff. There's nothing that's been asked to prompt that. So the issue is, was there a question that was asked by the police after the invocation of that right? Or was there no question and just an answer? Because if there was no question and just an answer, arguably, that could come in. But if there was more questioning that happened afterwards, if there was more questioning that happened after he said, no, I want a lawyer, and then he continued to talk and ended up confessing, then none of that comes in. So that's that. So the custodial interrogation, basically in its entirety, cannot come in this case, which is a huge blow to the prosecution, yes, because of the fact that he confessed to murdering his 3 very young, innocent, wonderful children. So horrible, horrible, horrible things that he confessed to. However, because of his rights under the Fifth Amendment and due to the outlining of those rights from Miranda and the cases that followed it, they can't come in. However, the court then looks at the Butcher interview and the Griffin exam. So Miss Butcher is a social worker who came in to check on him for his mental health, and then Miss Griffin came in to check up on his physical well-being, because he had made a an he had claimed that he was having some heart palpitations. So the main argument here by the defense is that they said that he didn't know that he was being recorded. So that's basically it. That's like the main crux of that argument. And it's a losing argument because of the fact that, well, he's in prison. I mean, or he's in jail, I should say. He is in an environment where you don't have nearly as many Fourth Amendment rights to privacy as you would, say, for example, in your own home. You don't have you can't possibly have an expectation for the right to privacy when you are in a jail cell, because there are it has to be balanced against the requirements of the um the institution, right? And the thing about this is that this is one of those environments where sometimes courts give deference to certain institutions, deference to certain people, groups of people, what have you, depending on the subject matter. And this is one of those where they give a lot of deference to the prison. So if the prison says, look, we have this requirement that we are, able to go in and search their cell for any kind of contraband, because we need to maintain a safe environment for not only the inmates, but also the prison guards. Like it would be ridiculous to basically allow these guys to have the same standard for their privacy rights for searches and seizures and that kind of thing. It would at a certain point render the ability to maintain these prisons impossible, and that does not serve the public as a whole well, right? Because of the fact that, like, we need to make sure that that people that are locked in prison are going to stay locked in prison for the duration that they are required to under the law, right? That has been determined based on the judicial system, based on their case, their sentencing, their verdict, all of that kind of stuff. By the way, Patrick Dunn, thank you so much for becoming a YouTube member. Welcome to Bite Club. Very, very happy to have you here. Support from you guys in through super chats and memberships and all that kind of stuff helps me to be able to focus on the kind of content that you guys really want to see, and not worry so much about like what's clickbaity and all that kind of stuff. So I really, really, really appreciate that stuff. And also to those of you who are not able to become members, but you want to support in other ways, liking the videos really helps. Subscribing to the channel really, really helps also. So that we can continue to put the time and energy and focus into putting great content out there for you guys. So thank you again. Okay. So the court kind of goes into this whole Fourth Amendment analysis about privacy rights for for someone who is in prison or in jail. And basically they go through and say, like, look, there are also certain requirements that the prison has. Let's see here. Okay, let me go down and kind of tie this into the actual words on the page. Yeah. Okay. So it cites to the Supreme Court case Hudson v. Palmer. And before we do that, Debbie Faison Cook, thank you so much for gifting 5 more Legal Bites memberships. Very, very kind and generous, supporting the channel. Awesome. I love it. Thank you. Thank you. So Pilola's mom, Olesia Chihova. Yeah, I think Chihova, maybe. Robert McIndewar, Catherine Lee, and Pamela H. You have all been gifted memberships by Debbie Faison Cook. So welcome or welcome back to Bite Club. Very happy to have you guys here. And once again, Debbie, thank you, thank you, thank you. All right. Okay, so this is citing back to the Supreme Court case Hudson v. Palmer. They say, we hold that society is not prepared to recognize as legitimate any subjective expectation of privacy that a prisoner might have in his prison cell, and that accordingly, the Fourth Amendment proscription against unreasonable searches does not apply within the confines of the prison cell. The recognition of privacy rights for prisoners in their individual cells simply cannot be reconciled with the concept of incarceration and the needs and objectives of penal institutions. So, I mean, basically, this is what I said, and just a little bit more succinctly and well put. Aussie J, thanks so much for the super chat. Love your content, Alita. Usually replay crew. Well, thank you so much for joining us this time. Very, very wonderful to have you here, and thank you for the super chat. I love it. Thank you. Okay. So, talking about the volatility of this community, prison administrators are to take all necessary steps to ensure the safety of not only the prison staffs and administrative personnel, but also visitors. That's true. I can say, as someone who has been to the California prison system for the purposes of depositions, I mean, it's a place. It's a weird place. Prison's a weird place. It's a weird place. It's kind of a scary place, especially if you've like never been there before. It is good to have those safety measures in place, to sort of make things a little bit more comfortable while you're there for whatever reason. Visiting people for family or loved ones or what have you, or to take a deposition of somebody who's suing the state of California. Okay. They've got to be alert to attempts to introduce drugs and other contraband into the premises, which we can judicially notice is one of the most perplexing problems of prisons today. Yeah, can confirm. An inmate told me all kinds of details that unfortunately will never make it out of my brain, as to like the various methods that they use to get stuff into prison. Okay. And then also, they talk about how they give a lot of deference to the prison administrations for a lot of this as well. Okay. Kitty cat is playing with my jewelry. All right. Moving on down. So also, there are certain standards that a county jail must implement and follow to provide the state mandated adequate medical care to inmates. And so this gets into some of the healthcare requirements. So it kind of then gets into Butcher and Griffin and the duties that they are actually fulfilling by going in and talking to him, going in and examining him. And these are like requirements that the jail system has in order to maintain the health and safety of these guys, whether that is their mental health or their physical health. So one of the things is as soon as somebody gets booked in, they have to they've got to send someone in to get his mental health information, because if there's something seriously wrong and they're like, well, we don't know if we can talk to him because of, like Miranda issues, or maybe he'll start talking and we don't want to, jeopardize any sort of confessions or what have you, like that would be ridiculous, right? Safety comes first in prisons, basically, is what they're getting at. And so, they get into all of this kind of stuff, but really, in my opinion, they don't need to go that deep into it. But the court, I think, is trying to be as comprehensive as possible, because, with an issue like this, there's a pretty decent likelihood of an appeal. Like this is the kind of thing that has a lot of Supreme Court case law. The Supreme Court has heard Miranda issues many, many times. And so, the likelihood of one side appealing this could be relatively, uh, relatively solid. So basically, that's why they get into this whole Fourth Amendment inquiry here. But in my opinion, even just looking back to Miranda, the default matter for Miranda also is, let's see here. And actually, let me see if I can, where is this here? Okay. Let's zoom in here or scroll over here. Okay. So the court gets, it basically concludes here. The court is satisfied that the state standards Ms. Griffin complied with intending to Doerman's emergency medical complaints satisfies the test required by Harper. Accordingly, the statements made by Doerman in response to Ms. Griffin's questions will not be suppressed. So what essentially happened here with both Griffin and Butcher was they both came in to administer some sort of health needs for him, whether it was mental or physical. Neither of them asked him any questions that were like substantive questions about the underlying crime, right? The reason why he was there in the first place. Neither of them asked for that kind of information. They asked him questions maybe, but they were questions related to his health. How are you feeling? How are you doing? Here's your blood pressure. Here's your heart rate. Okay, things are actually kind of okay. That's the nature of their communications with him. If he goes on to volunteer a bunch of information to them about the underlying crime, that's on him. Because the court also says here that the questioning of Doerman by Ms. Butcher and by Ms. Griffin do not qualify as custodial interrogation as contemplated by Miranda. And then it quotes to Rhode Island v. Innis, another Supreme Court case, U.S. Supreme Court case. We conclude that the Miranda safeguards come into play whenever a person in custody is subjected to either express questioning or its functional equivalent. That is to say, the term interrogation under Miranda refers not only to express questioning, but also to any words or actions on the part of the police, other than those normally attendant to arrest and custody, that the police should know are reasonably likely to elicit an incriminating response from the suspect. The latter portion of this definition focuses primarily upon the perceptions of the suspect rather than the intent of the police. The focus reflects the fact that the Miranda safeguards were designed to vest a suspect in custody with an added measure of protection against coercive police practices without regard to objective proof of the underlying intent of the police. So going on down, the court in this case says, assuming for the sake of argument that Ms. Butcher and Ms. Griffin were de facto sheriff's deputies during their encounters with Doerman, it is wholly unreasonable to suggest that they should have known their mental health questions and medical question would be reasonably likely to elicit in an incriminating statement, which their recorded interview unequivocally show they did not. So in other words, in order to trigger Miranda, let's say this. In order to trigger the requirement for hey, excuse me. You know what? I'm going to take you over here. So in order to trigger a Miranda warning and any kind of an encounter with the police, you've got to have two elements here. First, you've got to have custody, and second, you've got to have an interrogation. You've got to have questioning. So give me 1 second here. Yeah. So custody plus questioning. That's what triggers a Miranda warning. If you have someone who is not in custody, we talked about this, for example, with the Caitlin Armstrong case, the cyclist love triangle murder case. The police did something kind of tricky. First they arrested her under a warrant for some other issue that wasn't related to the murder. And then they said, okay, actually, like there was an issue with it. We're releasing that, you're not under arrest anymore. You can go whenever you want. She was someone who was previously in custody, technically is in the same room that she was in while in custody, now is effectively not in custody, because if she gets up and walks out of the room, no one can stop her. And they have communicated this to her. So she's physically there, but not in custody. And so because of that, they were able to ask her questions of like, and she also didn't strongly invoke her right to an attorney. She was like, I think maybe do I need a lawyer? I'm not sure. Like, she was ambiguous. And then she basically said, I'd like to leave. They asked her questions. She said, I'd like to leave. They asked her questions. She said, I'd like to leave. And they were like, you're able to go whenever you want. You can do whatever you want. You can leave whenever. But if you want to talk to us, we would love to talk to you. We would love to get your perspective. We would love to get your side. And so none of this was impermissible. It was all okay to include all of this, and all of that was introduced. There was nothing impermissible about that interview. Even though it technically was an interrogation, they called it an interview. Same thing. I mean, you've got police that are asking her questions and she's giving answers. The only difference was she wasn't in custody. So that's an important underlying baseline requirement in Miranda cases and Miranda issues is, were they in custody? And were they being asked questions? If they're in custody, but not being asked questions and volunteering information, then there's no Miranda issue. So you have to have the combination of the two. And so here, he was in custody, obviously. I mean, he's in jail, right? He's in jail. He's being examined by, Miss Butcher for his mental health and Miss Griffin for his physical health. So he's definitely in custody. And he's being asked questions. However, the questions are not related to in any sort of interrogation. The questions are not related to any sort of they're not anything. So like, just to quote the court, there's nothing about these mental health questions or medical questions that would be reasonably likely to elicit an incriminating statement. If they're like, how are you doing? And he's like, I murdered my 3 sons. Like, I don't think anyone would really foresee a confession coming from, how's your mental health, right? Those kinds of questions, oh, how does your heart feel? Like how is your breathing? Those kinds of questions are not reasonably likely to elicit a confession. So it's getting at the actual questions that are being asked. And also, like, is there something behind that contextually that we can draw from in favor of the defendant? And so basically this court says there's absolutely nothing here. So ultimately what the court decides is, as for the custodial interrogation, that is out. There's no way that's ever coming into court. It basically just wipes it from existence. It no longer exists as far as the court is concerned. Then we've got the two other conversations, we could call them, because they're not interrogations, but the conversations that he has with 2 other people, Miss Butcher and Miss Griffin, the 2 like healthcare professionals. And if he makes confessions there, it doesn't say exactly what he confesses in this, but I mean, if the defense wants them out, they've got to be at least somewhat damaging to him, right? So those are still going to come in. And so I know that this is one of these cases that, like, it angers a lot of people. It angers a lot of people because of the fact that we've got someone who has confessed to doing some very heinous, horrible, awful, tragic, heartbreaking things to his own kids. And so it's like, one of the reasons why I don't like to cover these cases, especially like gavel to gavel during their trials, is I can't live in them. They're so heavy. And I find myself, especially when it involves very young children or animals, being mistreated horribly or killed, or, animals and small children are, it's just especially difficult for me to maintain like professionality and the ability to look at that person and and give them the benefit of, you were innocent until proven guilty. And especially when it's their parent, it's really hard. It's really, really, really hard. So it's just, I understand why people are very angry about this, and angry about everything about this case, because, hey, um, it is a very human thing to want someone like this to rot in hell for all of eternity. But until that time happens, while he is still living, he has constitutional rights, and those have to be protected, even for people who have done the most heinous things. So, because if you want them to be protected for anyone else, for yourself, for people that you care about, You've got to be willing to protect them for the people that you dislike and that you detest, and worse than that. So where is this case moving forward now? What happens now with this case? Now, my understanding is that the evidence itself outside of these confessions is really, really bad for the defense also. He could still plead guilty. So far, he has not, is my understanding. This might bolster his idea as to his chances. But there's also 2 witnesses to the event that were also harmed themselves, but they survived. And so, you know, I would imagine that they would testify. And like I said, these other 2 conversations that he had, these other 2 confessions, these other 2 admissions that he made to these other individuals, are still going to be able to come in. So this case is not a finished case for the defense by any means. All right, let's see here. I think there weren't too many questions here. I'm so sorry if I missed some. But exactly, Christina, if freedom only applies to people and conditions you approve of, then that isn't freedom, it is privilege. Exactly. Exactly. That is an excellent way to put it. Oh, and here's a question that I think I may have missed. Cam, if you were in custody but the officers did not read your Miranda rights, should you just stay quiet and not remind them that your rights are not read? Sounds like this is a plausible way to help. I mean, yeah, it's just if they have not yet read you your Miranda rights, I mean, the best advice to anyone who is in the presence of the police is don't talk. Don't talk. Don't say anything. Don't, you know, so yeah, just stay quiet is the best recommendation for anyone in that position, whether you are in custody or not, because sometimes people will say things that ends up incriminating them, and there's no recourse in terms of Miranda because of the fact that they're not in custody. So generally speaking, best advice is zip it. Generally speaking. Okay. Has one wife and daughter were there. He's not getting away with anything. Yeah, that's my understanding as well. All right, folks. I think that about does it. I think Indy is telling me that she wants food, as is often the case. She's never not hungry. But that's about everything that I wanted to say about it. I mean, we've gone over everything here, and I think that's about it. I don't think I have any other thoughts that I wanted to give on this one. But thank you so much for joining me. And for all of your engagement, whether you are in the chat or whether you are in the comments, or if you are just watching and lurking and doing other stuff while you listen. I appreciate all of that. And as always, thanks to the mods for helping to make sure that the community has a pleasant experience of agreeing and disagreeing and doing so in ways that are productive. So alrighty, guys, that will about do it. And I think I'm out of here. Have a great rest of your day. All right, guys. See you in the next one.